It's more like, so not covered.
Welcome back to the Senate Committee on Government Operations Committee meeting of the last day of April 2026. Tomorrow is May 1. Up for our consideration next is the return of Senate Bill 298, which has been over in the other chamber for, I don't know, seems like 5-6 weeks, something like that. It's been a while. And they have amended it, I would say substantially. And there will be, although we won't get into it today, potential further proposal of amendment regarding the change of definition of PACs, or called political action committees. We're not going to get into that today, but because it's not in this amended version, it will be something this committee, should we choose to do it, will put in. One of the things that was added to this bill has to do with the disclosure requirements for candidates for state legislative and county office. And I'm sure everybody in the room is well aware of the unfortunate tension that is existing between the Secretary of State's office and the State Ethics Commission as to who will be responsible for a financial disclosure form. This amended version does suspend through May 10th, 2027, any enforcement and or penalties for any candidates for state legislative or county office who delinquently files a financial disclosure form required by Title 17. So while at least 2-3 of us here will be putting forms in, one of us won't be, you need to put your consent form in, your signatures, your petitions, and then also your financial disclosure.
Two financial.
Correct. One goes to Secretary of State and one goes to the Ethics Commission. And I asked yesterday, and I think I could say it out loud, it was in a private meeting, but I said, if someone doesn't file, they just say, hey, I'm not putting anything in this year, does that keep that person's name off the ballot? The answer is no. Your name still goes on, but it becomes a rather messy campaign issue for your opponent at that point.
Yeah,
so
it sure does.
Well, under current law, there's a fine imposed.
and this would suspend fine
$10 a day.
Yeah, I don't know that
up
I
to $1,000.
feel good about that, but
Anyway, Tim Devlin is here to hopefully get us through what is now called the Voter Protections Act of 2026. And you all have in your possession a printed copy of the Senate version, was in red, and then the changes therein. So that's in the separate document. Welcome in, Tim.
Thank you very much for having me back. I appreciate it, committee members. For the record, my name is Tim Devlin, Legislative Counsel. And you should have a, draft 5.1, a strike all amendment coming from the House, as well as an overview of that. It was just passed out of the House half an hour ago. So we don't quite have the as introduced yet, but they're identical. So if it's all right with you, Chair Caldwell, I'll just work off the overview and
Sure.
then if wanted, jump into the chat. And Bill, again, is not too long. The strike all is 8 pages. So on the bill, the first change you'll notice, and all the changes between the Senate and House versions indicated in red ink here for using reference, will be the change of the title of the act. Will now be called the Voter Protections Act of 2026. And then section 2, where we have amendments to 17 VSA, chapter 35. That is the pre-existing chapter titled Offenses Against the Purity of Election. That's where we find both civil and criminal sanctions against elections violations like voter fraud, misconduct by election officials, etc. And this, let's see, the House will now add some new sections in here, and let's see, one will be criminal prohibitions on interfering with voters and election officials, and the second one will be civil prohibitions on vote denial and vote dilution. And both of those will ring familiar. The vote dilution, language actually is substantially similar. Here, there's only one small adjustment made, regarding, the addition for protected classes, including race, color, or language minority group, also includes individuals with disabilities, as, defined in Title IX. They'll look the same. The voter intimidation election interference will look shorter than this committee remembers. As it came out of, the bill came out of this committee, there were actually 4 distinct sanctions, and this bill substitutes those with just a singular one that's covers, broadly speaking, most of the same prohibited conduct and activity as the 4 others did. You can just describe them as 4 others were much more particular. This is more generalized, but does address, again, the same conduct more or less. If the committee is interested, I can produce it side by side of the old language and the new one. The new language came over from another House bill and the Judiciary Committee, which was for 541, an act related to interference with voters and election officials. So let's see.
So
Yes,
what page is the new interference language on?
okay, that's your word.
Page 2. So we can just look at it here.
Absolutely, happy to read that. So this will be, I should just add that 1972, an existing law is being, have some language removed from it. That's essentially not the most clear language, and it would be made redundant by the to be added section 1975. So that's those removals are. 1975, interference with voters and election officials will read, no person shall intentionally or recklessly intimidate, threaten, or coerce, or attempt to intimidate, threaten, or coerce. 1, any other person for the purpose of obstructing the right of the other person to vote or to vote as the other person can choose. Or B, causing the other person to vote for or not to vote for any candidate in public office or public question at an election. Or, it's going to reread the top part again, no person shall intentionally or recklessly intimidate, threaten, or coerce, or attempt to do so a public servant, an election official, or a public employee for the purpose of obstructing the administration of election. So we have there 1, obstructing the voter, 2, obstructing election officials, as well as election administration. Then B, line 18 of page 2, we have the sanctions. The person who violates subsection A, the section should be imprisoned not more than 2 years or fined not more than $2,000. So,
Senator White.
Can I just ask, like, intentionality related to those sections? Like, I think what I've heard from other legislators and what we heard on the floor from Senator Ingalls was less like a concern about not doing the form or avoiding doing the form or intentionally sharing bad information on the form, but rather which form, how do I do it? Does the language in the House or the Senate version have anything with like intentionality? Like if you didn't know or weren't given proper information, is there anything to that? Or maybe that's something to change?
what I just read for the committee was really just the voter interference.
Yeah.
The voter disclosures are just later on the bill.
Yeah.
And the, how to properly file a form, that language isn't really being changed by this bill.
At all?
The enforcement, mechanism behind that, delinquent or improperly filing it, that's being suspended for a year.
Oh, my fault.
Senator Ingalls.
That's right.
I also have a question about intent, but it is on this section.
Sure.
And it is, and I may have actually asked a similar question when we walked through the bill a little bit in judiciary. But it is sort of, as I'm thinking about like the levels of intent, and I think there were 3 of them, and it includes recklessly. And I guess I'm having a hard time understanding how one recklessly interferes with voting.
Sure. It does lend itself more to criminal threatening kind of, and but true threats, as we're going to unpack that in a bit, can certainly occur in efforts to either intimidate voters or intimidate those individuals who are charged with conducting administrative elections too. Election official receiving a threat which the recklessness comes in as a mens rea, could, for those reasons, not do their job or do their job in a way otherwise they wouldn't have done properly. And so the standard, just kind of return to the language here, of intentionally or recklessly, intimidating, threatening, or coercing either individuals trying to vote in the way they choose, or public servants, elected officials, and public employees who are obstructing the election. That, because it's a criminal statute here, and to consider both the mens rea, which is the mental state of the person conducting it, and the actus rea, the actual conduct coming out here. But when it comes to what should that mental state be, the U.S. Supreme Court has weighed in on that. And this is where we're getting to, we were referring to before, about the 3 layers of levels of how intentionally should the person be acting if they're to be held criminally liable here. And so the first one, the highest on the rung of the mens rea ladder, is purposely or intentionally, as we use it in our statutes here. They're synonymous. And that really means somebody consciously desires a result. So whether that's, and then you can kind of apply this as you will to what it means to intimidate or to force. Next one is knowledge or knowingly, and that is being aware that the result is practically certain to follow. Third is recklessness, and that is the conscious disregard. Somebody who consciously disregards a substantial and unjustifiable risk that the conduct will cause harm to another. In the threats context, this means that a speaker is aware that that others could regard his statements as threatening violence and just delivers them anyways. So it's, you know better, you just don't care. And then negligence is actually 4 points below that, and that's if you're not aware of the risk before you should be aware of the risk. So this is knowing the risk, not caring, but it offers here 2 different mens reas which they could choose. Recklessness is the lowest you can get while having a criminal statute be constitutionally viable, and that's another case called 2023 Colorado v. Kennedy, where they established that. It can be criminal threats have to be this mens rea or higher. Right. So this reflects that constitutional bare minimum as well as provides an option for highest level potential.
So I looked up recklessly. I looked up and it's good because these actions should be caught here. Recklessly is an adverb describing actions done without caution, like not thinking about it, care or regard for dangerous consequences. So spontaneous of the moment, not really fully thinking out and yet harmful.
Yeah. And it's even further defined in common law. The judiciary will treat it as a term of art. And you're not.
You can be recklessly driving and you could be pulled over for that. I mean, that's a misdemeanor.
Yeah,
so it's commonly used in context regarding dangerous driving, irresponsible speeding, or causing harm. And so
No, and I appreciate that. And I have sort of an additional question that doesn't have to do with that, but then a statement that sort of has to do with that. I understand spending my mornings in judiciary, the concept of reckless behavior from a legal context. What I'm having a hard time understanding in the context of the behavior we are talking about is how one engages in that behavior without intent. Like if I'm threatening someone, I intend to threaten them. Like how do I recklessly threaten someone?
Sure. That would be example. That would be an individual who may disagree whether they think they're threatening you or not. Right? Person A says something pretty off color. Person B says, "Oh, you're threatening me," and then there's an immediate disagreement. No, I'm not. You're thin-skinned. Where does it kind of come into? The recklessness standard states that the speaker, whatever they say, if they knew that it probably would have been considered as a threat by the other person, but they just didn't care whether or not, so they didn't conduct themselves in a manner that was respectful of that idea, that what I'd say could easily be considered a threat by most reasonable people. It's a reasonable person standard. I mean, that show that, you know, the person's like, nobody's going to consider that a threat, you know, by saying, I'm going to, you know, it is Thursday today. All right, that's not a threat, but if I make something about like, you know, you can choose your thing, and so far as most people consider that a threat, the person no longer has any excuse. Well, I didn't mean it. It's really like, oh, well, everybody else would have assumed that's what you meant. You probably did know that, but you just didn't care. You went ahead and said that anyways. That's what
Okay.
reckless is.
So then- My sort of follow-up to the larger conversation around mens rea is, so we include intentionally and recklessly. Why would we leave out knowingly, which is in between the two? Or is it sort of automatically looped in because we
Yeah.
include the
I
bookends?
really only need reckless. And then you could, and if you're doing something intentionally, it would be shown by recklessness above, because recklessness is a looser standard.
Okay,
That's lower down.
So-
So is intentionally redundant? Arguably, yes.
Okay.
But, yeah, they just have to prove beyond, at recklessness would be beyond that. Intentionally. Senator White?
Yeah, to that point, I'm trying to think of like, because I think I'm trying to give a real world example. It's always helpful for me in this situation. Could recklessly be like if I'm in this scenario, a person at the front of the voting area, and it's my job to give people the ballots. And I know that this person lives in town, and I'm going through the checklist and I say, I don't think I see you on here. Can you even prove that you're on here? Or like I kind of hassle them. Would that be considered? I mean, giving that person that feeling of like, maybe you shouldn't be here, but not saying, oh no, you're not on the list.
That would probably be caught up in one of the other pre-existing, offenses, against the purity of
That's
election,
right.
misconduct of election officials, where if you're materially misrepresenting somebody or preventing, you know, lying about.
That would already be-
That's already there.
Okay.
Here,
Yeah, I guess that's not a good example. It's already covered. Would it be like even be standing outside and well, no, I guess that would be in the other one as well. Because time and date was so important when we talked about this before, and specifically giving inaccurate information related to that.
well, that was
Um,
about actual facts for the AI stuff.
And we had it in this bill as well.
so when there was 4 different distinct, violations, that was some of the language in one of those, yeah,
Okay. Well,
like this manner.
I will doodle on
It's
this.
sort of like being, something happens and you erupt in an unexpected, you know, that something triggers a response and you go into a rage or something and intimidate in that way. That would be it's kind of like throwing caution to the wind and just responding in some close to irrational way.
Okay.
It's like,
A little more along the line.
And where intent can't be proven if there's no plan.
Right.
I would argue
There was no plan.
capture it,
But
but
something triggered it and
if I come up to somebody if I encounter an election official or I intercept somebody going to vote and I say, you're a cat. If I say you're a dead man,
Oh.
you know, that's suddenly going to be well understood by everybody. And I should know that is going to absolutely be
Yeah.
considered a threat by most people. But because I didn't care about what you thought and said it anyways,
Yeah.
that's reckless.
Boom. That is,
so it's
that,
the more spur of the moment that things that lack intent, the behavior may be ultimately the same, but without the planning and intent behind it.
The premeditation isn't really
Okay.
here. It's just whether, I mean, yeah, yeah,
Okay.
it's less important, I should say.
interesting. Okay.
Do you want another example?
I mean, if you got one.
Yeah, so you're standing out in front of the pole, and maybe you have your lawn sign, some areas allow that somehow.
Yes.
And somebody comes up to vote and they're waving their arms and saying, you're a horrible candidate. Nobody should vote for this person. I would think that's pretty reckless.
Let's see.
Well, yeah, but you're waving your arms, you're physically,
But there's no threat
Well, and,
or
You can
misinformation.
knock it out of my hand.
and let me reread the,
okay, maybe it was a bad example.
I thought
So recklessness is when one consciously disregards a substantial and unjustifiable risk that the conduct will cause harm to another. In Fred's context, it means that a speaker is aware that others could regard his statements as threatening, violence, anyways. So if you're, swinging your arms around, you consciously disregarding a substantial and unjustifiable risk that'll cause harm to another person. Yeah, it's likely if you're coming close to making contact with some people and dodging you and
Yeah.
preventing them from actually voting. Or you scare them away or something like that. The election official runs away because he's
So
going to be better.
page 2.
Well, I love that example actually, because we did have a situation in Springfield where I would have argued there was reckless behavior with a
Yeah.
flag. And where
Yeah,
people were
hard.
using a flag that felt inappropriate and threatening. So
As a weapon before.
I would say is a blocking tool, very large flag, very, very large flag, like as large as a human being.
We had a recklessly.
They were physically impeding people from entering the polling location.
They were in an unlit area waving the flag very close to the entrance in a way that felt intimidating to me. And it was a giant American flag and a giant Trump flag. So you basically had to go around them to access the polling units, in my view, in a very unlit
Were
area.
you there when Coach and I were attacked by that what I would call reckless behavior by the guy? And remember, Coach took him and then he had to do diversion.
Yeah, well,
That was
that's the guy who I report to
That was reckless.
That was reckless.
Okay. So page 3?
Sure. So,
Or back to your summary.
I
I was stalling for John.
Because you were on the
okay.
second the first red pair.
Yes, so toward the bottom of page 1 of the overview, we have a new section to the 17 VSA, 1976, impairment of voting rights of registered voters. And this was part of the Voting Rights Act, as it left portion of the bill that is left here to reorganize here. Still it's the same effect as it applies to the entire chapter, but it just seems to fit better here. It reads, it's added stating that nothing in this chapter, as offenses against the election shall be construed to deny, impair, otherwise adversely affect the right of vote of any registered voter. And then we move on to a new subchapter 6, voter protections. And if you flip over to page 3 of the bill, you'll see it's kind of include the other subchapters that were added by S23 synthetic media bill, just to give a frame of reference where things are. So we have the use of synthetic media will be subchapter 4, subchapter 5, enforcement investigation, or the enforcement investigation, civil enforcement investigation. Powers provide to the Attorney General's office to look into any misconduct underneath this chapter. And then we'll add a new subchapter 6, having to do with voter protections. And this is the almost identical language that was carried forward from this committee's bill. The House is just going to reorganize into chapter 35. So those AG enforcement investigation powers will apply to them. They had asked numerous times to begin those. And so this is somewhat elegant solution, just moving around and putting it into a different chapter that had that apply. The only difference between the two we added 17 VSA 2045 and 46 as a from how it left here is that we have, you can see on page 4, the definition of protected class means a group of citizens protected from discrimination based on race or color, membership in a language minority group is the same as new language, or having a disability is defined by 9 VSA 4501. And then that language is also duplicated.
How does that language intersect with the Constitution? Because we have a whole constitutional provision and an amendment to that provision in process that defines what is a protected class. So can we say constitutionally that members that we include in our Constitution as a protected class don't have protections here?
So you're referring to the Vermont Constitution?
Yes.
Protected class?
Counselor, is that what you're talking about? Yes.
I apologize. I'm unaware of the language of Prop 4.
Well, Prop 4 just expands, we have, it's an equal rights amendment, but it's expanding existing language that, I think, I have a copy of the Constitution in here.
Get in there.
So I guess if Prop 4 were to pass and So you're saying that it affects, I have to look at the Constitution. To pull up the-
I'm looking right now, and I will, but my,
I'll just look online. So if there's a question about if it's defined in Constitution, can the definition of statute differ?
and not include as being less protective than the
It's less
Constitution.
protected. It depends on the context in which the Constitution uses the term. It strikes me as it possibly could be the same context here. We're dealing with fundamental rights of equal protection and vote. Fundamental right. Let me put a pin in that right now. I can look into language profiting and Constitution. Get you better.
Could you put another pin into what is membership in a language minority
Oh,
group? Sure.
That's not defined in statute or elsewhere in Vermont statutes annotated. It's something that's been explored, I believe. It's a part of the Federal Voting Rights Act, and I'm trying to think if it's, I don't think it's defined in statute, it might be defined in regulation there. But I can say it's essentially we're not further defined here, because I know there was further defined in prior versions that came out of this, that this committee was contemplating. They're probably read by its plain language, meaning, okay, what is the language majority of this country? English. Language minority would be all others. Right. Yeah. Wow.
I think,
But it's open to interpretation because you don't define it here. It is, I think.
So I'm just following that logic through. Does that mean that the ballot has to be printed in a language minority group's language?
No, it does not necessarily tell that, although there are
I mean,
other
the
language.
translator is generally.
There
there
are other
with you.
provisions in Title 17 getting to that. Actually, maybe more local ones. But this really, the meat of it will be kind of returning to page 3, 2045A. No voting qualification or prerequisite to vote or to voting or standard practice or procedure shall impose or apply by the state or municipality in a manner that results in denial or abridgment of the right to vote for any citizen of the United States based on membership in the language minority committee. So then we return to, okay, what is meant by a standard practice or procedure? We don't define that in statute. However, federal case law, sweeps in everything from reapportionment practices. That's what we see in Title II of the VRA, what this language actually comes from. The things like tests or methods for registration, the placement of certain infrastructure, like drop boxes for things like that. It's broad language, I think really intended, at least when it's introduced to the federal and other state VRAs, to be broad so it captures a bunch of different things. Whether that requires ballots to be printed in various languages that are not English. There's the statute is silent. I'll have to look into other statutes in 17 to see if there's similar language. I think there is. I don't know off the top of my head exactly what that entails about providing sample ballots in different languages versus printing all ballots and making them available or something like that. I have to take a look.
Well, I think it would put additional costs on the municipality to have to have a Taiwanese ballot, just as an example.
Well, I think it reflects the
With all
community. You
respect.
print them in the languages of the people in your community and after they have something.
That isn't what it says.
Well, you're not gonna,
Well, that's why I'm asking.
yeah, no, good question, because it's less expensive to print things in other languages than it is to hire a translator to be there all day to wait for people who may need translation help.
Senator Wayne,
And
I was just gonna know, I think we had some extensive conversation when it came to what percentage a language minority had to be within
Yeah.
the redistricting conversation.
it was,
Yes, good memory. Yes.
right, so the original bill did have mechanism for identifying what constituted a, minority language group.
Yeah.
And it was, there's two kind of competing mechanisms between different versions of the bill. One, I think, had it just based on demographics,
Yeah.
and then others would, the other one had it like the Secretary of State would designate and
Yes.
then provide additional resources and services for producing resources
Yes.
in different languages to qualify for that. I think both were somewhat tied to, how much of what portion of the population speaks the language, and also maybe there's contemplation of limited proficiency in English too versus, just having it, bilingual population or something like that.
And we took both of those out of the bill, if I remember correctly, towards the end of our time. So I don't.
all right, I just noticed it and I went,
Sure. And I can look into that more, think about it.
Okay.
Yeah. Why did the prices like?
Yeah, that is a big burden it should be determined by community. Who has what languages spoken in their communities.
Office of Racial Equity might be able to weigh in some on that, given that that office has done extensive work on language justice or the lack thereof in the state of Vermont.
Well, the House took some testimony on this matter. I'm not sure if it was, I know that the Secretary of State's office provides some information. I don't know. I have to look at it.
And-
Maybe an AG's office or.
To tag on to that, the refugee resettlement group knows where people are living, so they know the communities people are living.
okay,
This would be.
just in the interest of time, we probably ought to move along.
Oh, now, I say one last note on that, it would be community by community basis, just because that's how elections are administered, for the most part, on the local level. So, let's see. That being made the same. Page 2, get outline. Okay, section 3 of the bill has to do with voter checklists. So this will amend 17 USA 2154 statewide voter checklists, particular subsection C. It will require that any person wishing to obtain a copy of a municipality's portion of the statewide voter checklist or any other municipal voter checklist shall swear or affirm on penalty of perjury that the person will not A, use the checklist for commercial purposes, or B, knowingly disclose the checklist to any foreign government or to a federal agency or commission or to a person acting on behalf of the federal government or such a federal entity.
Foreign government.
Foreign government, yes. In circumvention of the prohibited purpose for using the checklist. And so the existing law only explicitly requires this to happen for statewide voter checklists. So basically, creating mimic mechanisms for the local.
And it would fall upon the municipality to provide.
Yes, yep, and then there's some filing requirements about clerk or secretary, so it gets it depending on the district. Part 3 of the bill, and this is where we have sections 4 and 5. This has to do with disclosures for candidates for state legislative and county offices. Section 4 will then 17 VSA 2414, that is the statute that requires those disclosure requirements to be completed and submitted by candidates for state and legislative, and county office. And this will add a new subsection F that will require the State Ethics Commission to provide informational resources to candidates and answer their questions. There's some describes hyper specific requirements about posting, what they have to post, including not only the disclosure form, but basically FAQs and other informational resources to those candidates. The Secretary of State's office shall provide hyperlinks to the materials that are to be posted by the State Ethics Commission on their web page. Section 5 will suspend for approximately a year, that is through May 30th, 2027, enforcement and penalties for candidates who are to be filing those aforementioned disclosures. If they just file them improperly or delinquently filing them. I should note that the provisions of 2414 have not been suspended, so they are still required to file them, but there'll be no penalty if they don't for a year. Part 4 of the bill has to do with safety protections for the candidates. This will look familiar. This idea passed out of this body, but some of the exact verbiage has changed. And so, whereas before, and just situate ourselves, we're in the campaign finance definitions here, 17 VSA 29.1, specifically 7 for the definition of expenditure. And expenditures may include, or the definition shall include, those expenditures that are incurred for the provision of monitoring systems, protective detail, and cybersecurity related to candidates' security, and not just for the provision of security of candidates.
So for those who may not remember, our original language, and it was brought up in the House Government Operations Committee, just said protection. So someone said, so I can use my campaign finance to buy a gun. And the answer is, yeah, you can. So this is an attempt to further clarify that. My question now is protective detail. Does that mean I can hire 2 bodyguards?
Yes. Maybe for a special event, you might want to do that.
Oh, God.
Essentially, yeah, security.
Well, I picked Morley and you.
We are a team.
Why do you think I haven't thought security yet?
I was just curious. It just seemed like an odd. I mean, the only one that I know that has a detail is the governor.
Yes.
But there are
As you
occasions
we
where
argued about this.
Yes, I remember. And I'm glad we didn't pursue it because it.
But I can see saying yes to being present for an occasion that is a very, possibly quite,
Really?
I can give a real
dangerous
world
situation,
example.
yeah.
In the last election cycle, I had someone who was threatening me and stalking me, and I was asked to speak at an event that happened in the park that was across the street from his house.
Okay.
I asked people who I know who are stronger individuals to be there with me should that person who had threatened to harm me,
Okay.
stalked me at my place of work and home, cross the street and come to the event.
But you didn't pay it.
Well, I didn't because
you luckily knew strong people. who would-
I luckily was able to put the call out to people who had asked me to be there and friends of mine who were able to beef up the
Well,
number of people.
Yeah, I'm sorry to hear that. That's really disturbing.
It is.
Luckily, I've never. I mean, I had somebody drive by and flip me off,
Yeah.
yell at me, but that isn't.
I
I'm
can't
not going to hire a
believe that.
bodyguard for that. Huh?
I said, I can't believe that. It was probably from a referee, man.
I'm angered.
Monitoring systems, I assume means you put a camera on your garage door and. Yes. Well, cybersecurity, I don't know what that means, but.
That might be some of the your information from a data broker site. Yeah.
Oh, okay. Well, if you guys are happy with protective
Oh,
detail and.
I think that's all fine. And
Oh.
women, that's an issue, Seth.
Senator Farson.
So if I just understand, because I did hear the GovOps committee had like a lot of debate about the gun piece. And my understanding is, yes, you could buy a gun in both versions of the language, in our original language and the changed language.
Yes, the way our campaign finance statutes are written, we define what it is, but we actually don't prohibit use of campaign funds for things like personal use, like a lot of other states do. Then define what is personal use, kind of distinguish what are allowed things to spend your money on and what aren't. We don't do that here.
Okay.
Yeah.
Well,
So if I wanted to pay my rents with my campaign finances funds, I could do that.
You'd have to be a pretty good salesman.
yes, to that point, even if there's no real prohibition on how to spend that money, there's disclosure requirements.
Hmm.
And so I suppose
Yeah.
you can count to the public.
Yeah, that's good.
Okay.
So we've arrived at 255, we were supposed to take up the dog sled testimony.
Is he
At 2:30.
by Zoom?
These are the order.
Okay.
So the other thing, and I know people have strong passion feelings about the Supreme Court ruling of yesterday,
I mean, the outrageous report.
but I would ask you not to display those too strongly when we start talking about the bill. But there is an intersection with this bill and that ruling. I'll just make that
Yes.
statement. I don't think we have time today to go into it. We don't have possession of the bill anyway. We won't till Tuesday. But it will be something that we should talk about.
Yep.
And I'm referring specifically to the section about voter dilution. I think that's where the intersection exists. I'm not sure that Vermont, when we reapportion, for the most part, it's geographical and population based. It's not based on race, as opposed to other states where that may or may not happen. So I don't know that there's a severe intersection, but there are parts of the voter, whatever we're calling it now, the voter protection bill, that could potentially come up in a legal world. And we can look at those when we go further. That's all I'll say. And I understand, trust me, I understand that you feel very passionately about the decision, but I don't know that it serves the purpose of moving this bill along to kind of refer to that concept.
No, I think it just underscores its importance. So that's,
Okay, and that's fair.
and that is, I think, fair.
But this will be something that, and I'm not trying to presuppose anything, but it probably it's going to go to conference committee. I don't know that we can iron it out in the next week or so. If the